Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about how the airlines in Canada lost big at the Supreme Court and how that's going to cost them a bunch of money, and some of that money might end up back in your pockets. So this is the case of the International Air Transport Association and the Canadian Transport Agency. In the US they'd say versus, in Canada we say and. So what happens in this case? Well, the government put forth a bunch of laws that allowed them to demand compensation, minimum compensation from airlines in the event that they, well, screw you over. If they decide to cancel your flight and it's their fault, then they have to pay a minimum amount of compensation on your request. You do have to actually put in a request and ask for it, but they have to pay minimum compensation. So the airlines, of course, really didn't like this. They liked the idea much better that they can do pretty much whatever they want to you. So they decided to challenge this. They took this into federal court, where they lost. And then they took it up to the Supreme Court, where they lost again. So let's talk about what's happening here, what this case is about, what their arguments were, and why they lost. And we'll talk a little bit about what it means for you. So let's dive into the case here. It says the regulations include provisions dealing with standardized amounts of compensation for international flight delays, cancellations, and denial of boarding when the disruption occurs for reasons within a carrier's control, i.e. not things like weather, and is not required for safety purposes, and refunds of baggage fees paid by passengers when the carrier has lost or damaged their baggage on international flights. So if you paid extra to have that, to have another checked bag and they lose your bags, they have to refund that extra payment. Now, you might be wondering, what kind of compensation are we looking at here? Like, are we talking huge money? It's not really huge, but it is significant. So let's have a look at the regulations here. They say if paragraph 12, 2D or 3D, these are delays or cancellations with less than 14 days notice, which is pretty much all of them. But keep in mind that there are those exceptions if it wasn't their fault, weather, etc. So it must provide the following minimum compensation. So in the case of a large carrier, which most of us are flying large carriers, if the delay is more than 3 hours but less than 6 hours, they have to pay you $400. If the delay is 6 hours but less than 9 hours, $700. And if the delay is more than 9 hours, then they have to pay you $1,000. However, there is a little wrinkle on that, which is if they've provided a refund, then the minimum compensation, they can pay you more if they want to. They don't want to, but the minimum compensation goes down to $400. So they clearly don't like this because they don't want to pay you $1,000 if they cancel your flight. This can also affect the decisions they make in terms of canceling a flight. Because if you think about them saying, well, it's just not worth it for us to run this flight, it's got no it doesn't have enough people on it. Well, if they have to add $1,000 for each person, well, then now it starts to add up. Now, keep in mind, most people, when they're flying, those flights are significant to them. They matter to them. If you're flying for business, there may be consequences if you don't make it. If you're flying for pleasure, it might be that you've been saving for 3 years to go on this vacation, and if it gets canceled at the last minute, you might just be out all that money. So, what was their argument? What was the airline's argument? So the airlines allege that the regulations conflict with the exclusivity principle of the convention for the Montreal Convention. Everybody just calls it the Montreal Convention because it's got way too many words in it. So what does that mean? Well, it means that the Montreal Convention has rules that basically provide for compensation for passengers. And it says these are the only rules that will govern compensation for passengers. So that was intended specifically as an international treaty to limit what governments could do with regards to airlines. And this treaty really is in favor of the airlines because I suspect that the airlines had people lobbying during this and you didn't. That's just kind of the way. So they say it, and are ultra viras the agency's regulation making authority under the CTA. Ultra viras means outside of your power. Let's say the local, the local motor vehicles branch decides that they're going to make a rule that says that, you know, you have to be able to recite the anthem in order to get a driver's license. You might think, oh, that's a good idea. The problem is it's not within their power. They don't have that authority. Ultra viras, basically, a lot of law divides up which people in government get to make which decisions. And so ultra viras basically just means it's outside of this power belongs to someone else. You don't get to use it. So Canada signed the Montreal Convention in 2001, and it was implemented into Canadian law by amendments to the Carriage by Air Act. Article 29 of the Montreal Convention codifies its exclusivity by stating that any action for damages is subject to the conditions and limits of liability that it sets out. And right here is all of the action in this case. Any action for damages is the key phrase, because if these issues are an action for damages, then the Montreal Convention says only the Montreal Convention gets to decide this. Whereas if they're not, then the government can make other rules. So how does the Supreme Court decide to deal with this? Well, they dismiss the appeal, so the airlines lose. But they note Article 29, in explaining the exclusivity principle, states that it applies to any action for damages, however founded. The ordinary meaning of an action for damages points towards an action and an action they mean like a legal action, right? Like a lawsuit, that shares the characteristics of a judicial proceeding and that seeks individualized compensation that is tied to an injury caused by another. One key word there is individualized. And so you can see already that the Supreme Court here is differentiating the individualized compensation from the blanket compensation that is provided by these regulations. So damages awards are individualized in that they seek to compensate the plaintiff for the loss suffered as a result of an injury caused by another. An action for damages is distinct from standardized compensation, which may be owed identically to all claimants, i.e., everybody who got their flight canceled gets the minimum of $1,000, no matter what, right? Irrespective of the harm, if any, they have suffered. So what do we mean by this? Well, let's say normally in an action for damages on this, you'd have to point to the actual injuries you suffered. Like, what did you lose? So you might point to, listen, you said I was going to fly on, these dates. And so I had a hotel booked on the other side. I was going to stay in a hotel and I had to pay a non-refundable deposit to secure that hotel room. I lost that when you canceled my flight. So I'm out that, $400 that I had to pay there. Or maybe you had, concert tickets that you were going to go to another country to watch a concert. And because they canceled your flights, you weren't able to use those concert tickets, so they were wasted. That's also damages. So what they're saying is the Montreal Convention, the action for damages, deals with those specific things that are specific to you. Whereas this is something for everybody. Everybody whose flight got canceled is entitled to the $1,000, regardless of their circumstances, right? So it doesn't matter if you lost a hotel room and you had a car booking and all of those things. So the court continues, the regulations are best understood as providing for statutory entitlements under a consumer protection scheme. Passengers claiming under the regulations need not show what harm, if any, they have suffered in order to claim compensation. The regulations do not tie compensation to harm or inconvenience. They mandate compensation for delay, cancellation, or denial of boarding based on the time by which a passenger's arrival at their ultimate destination is delayed, and compensation owed for lost or damaged baggage is tied to the baggage fees charged by the carrier, not to the harm, i.e., you have to repay what you charged for the baggage, right? So you choose what that is, but it's not based on harm. Now, they could have decided this the other way. They could have said the harm is exactly equal to the baggage fee. But Um, You'll also notice that this kind of provides a really good incentive to airlines because let's say you have a flight that is canceled and it's canceled for reasons that are the airline's fault. Well, if they can rebook you and get you to your original destination and it's within 3 hours of when you would have arrived anyway, they don't have to pay you anything under this, right? They can avoid that by helping you out. Whereas if they are unable to, then they have to pay $1,000. So this provides them with an incentive to try to get you to your destination. I really like the way that works. I think that's a good thing here. So, unlike the Montreal Convention, the regulations do not enable a carrier to avoid having to pay compensation otherwise due to a passenger by invoking a due diligence defense or pointing to contributory negligence. Due diligence is basically we did the best we could and it was, a reasonable amount of, it's basically it's not that things were impossible to fix, but you tried your best, right? You did, and so you don't owe the money because you tried your best to avoid that circumstance, and it was an appropriate amount of trying to avoid that circumstance. Or pointing to contributory negligence, which is negligence on the part of the passenger, right? They lost your bag, but you used a crappy bag, so that's kind of your fault, right? So as long as the disruption in question occurred for a reason within the carrier's control and was not required for safety purposes, the compensation is fixed. Moreover, the agency is empowered to extend a finding that compensation is owed to one passenger to other passengers similarly situated. So once they've decided that, like, the passenger sitting in 1A on the flight deserved compensation, they can just apply that decision when the guy in 1B shows up and says, I also want compensation because they also canceled my flight. All right, so this is kind of an interesting case. They note, I return to the purpose of the Montreal Convention and the role of the exclusivity principle referenced in Thibodeau, which is a previous case, later in these reasons. They're talking about the purpose of the law. What was the function of it? Why does it matter? They say, for now, it suffices to note that this court has recognized three central objectives of the Montreal Convention. First, it limits carrier liability related to claims for damages for death or bodily injury. Now, limiting carrier liability is unquestionably good for the carrier, and it's unquestionably bad for you, the passenger. So damage or loss of baggage and cargo, and for delay. So as an example here, the Montreal Convention limits damage, like for baggage, if they lose your baggage, to I think it's somewhere around $1,700 currently. So if you are flying with a laptop, and if it's a nice laptop that you've got in your bag and they lose it, $1,700 might not go very far. Clothing can add up really fast. Jewelry adds up incredibly fast. So sometimes people are very surprised to find out that those limits can be very punishing. If you're flying with, a bunch of jewelry, well, too bad, I guess. So, second, it protects the interests of passengers and shippers by creating presumptive liability for carriers with respect to those claims, so it's easier for you to win. And third, it seeks to create uniform rules governing claims arising from international air transportation. And this is kind of an interesting case as well, because they also end up doing something that courts almost never do, which is that they go to, like, Black's Law Dictionary, and they almost never actually go to, like, the dictionaries these days, or at least Black's Law Dictionary. I've owned a Black's Law Dictionary for forever, but I've never actually ended up needing to use it for a court case. But the Supreme Court just cited Black's Law Dictionary. That said, if you ever see something online that tells you a quote from Black's Law Dictionary, that quote is probably false. Most people who are sharing quotes supposedly from Black's Law Dictionary are sharing false quotes that are not actually found there, especially if you see, for instance, a quotation for monster or something like that. All right, so this is a really interesting case. There's other stuff in it to nerd out about if you are a legal nerd, but I don't think most of you will care. Um, so there is a really interesting thing about the admissibility of expert evidence for international laws. That's really more academic and nerdy. But what does this mean? Well, it means that there's actually a bunch of compensation that is held up. And so Canadian air travelers might actually get a little bit more back from airlines when the airline kind of mistreats them. I don't know if you've flown recently, but flying as an experience kind of sucks. It's kind of miserable. It's kind of garbage. And there's a lot of circumstances where you'll go and they'll just be like, yeah, your plane just isn't happening. And then you're like, oh, well, that sucks. What can you do for me? And they say, nothing. There's also some provisions in this that require them to, for instance, if you've ever been stuck in an airplane that is stuck on the tarmac, they're now required to, for instance, provide you with food and water. And if the plane is going to be stuck for too long, they're required to give you an opportunity to leave, to disembark. So all of those are good things. I'm also just going to say, and you may not hear me say this often, this is a rare win for the Liberal Party of Canada. Credit where it's due. This was something they pushed through, and they were sort of trumpeting this as a big success on Twitter, and they're not wrong. I actually think this is a win. So good for them. But yeah, the airlines are also required in the event that you are covered by these things to provide you with information. So one thing I will say is if you're flying in Canada and the airline hands you a thing saying you might be entitled to compensation, here's how you do it, you should follow those steps because it might actually be decent money. $1,000 is not nothing, folks. I'd certainly like $1,000. But yeah, so this is a big deal. This is a big decision, and I think that the Supreme Court could have gone the other way. I think that some of their interpretation here was a little generous towards the consumers, but I'm okay with Joe Consumer getting a win for once. The corporation's taking a loss. It's like, oh, that almost never happens. Win for the little guy. So, good work, Supreme Court. I approve. This is a decision I'm entirely happy with. Let me know your thoughts in the comments below. But I thought this was a good decision, and hopefully it'll lead to some improvements in air travel within Canada. Anyway, thank you guys for watching. I hope you found this to be interesting or educational. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Bottle Shock and Oz, Canada's National Farm Association, PJ's Forever, CCFR, CMP, Cielo, Purple Dragonair, and the Canadian Shooting Sports Association. I also want to thank at the $20 level Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elisich, Marvin CZ, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you guys so much for watching. I hope this has armed you with knowledge. See you next time.